This is the story of a people's fight for the sacred right of suffrage. During the Spanish regime in the Philippines, such a right did not exist. It was only when the Americans came that the right to vote became a statutory right, subject to the control of the Philippine legislature. They granted enfranchisement to a portion of the population, particularly the male ilustrados, for it was their belief that suffrage is a privilege granted by the state to such persons or classes as are most likely to exercise it for the public good. In 1935, it became a constitutional right. This time, Congress could no longer grant nor withhold the right at will. For the first time, the right of suffrage was extended to literate women. As part of the scheme to broaden the electoral mass base, the 1973 Constitution lowered the voting age to 18, removed the literacy requirement, and made it an obligation for every citizen qualified to vote to register and vote, to the point that a presidential decree making failure to register and vote without justifiable reason a punishable offense. Many believed this was an attempt by the Marcos regime to clothe farcical elections with legitimacy and prevent the use of election boycott from becoming an effective instrument of electoral protest. But it was precisely the recognition of electoral boycott as a legitimate form of protest that prompted the 1986 Constitutional Commission to do away with the constitutional obligation to vote. Our fundamental law now reads, "Suffrage may be exercised by all citizens of the Philippines, not otherwise disqualified by law." Suffrage as a right and duty was given to those who possessed the following qualifications: Philippine citizenship, age of 18 years or over, residence in the Philippines for at least 1 year preceding the election, residence in the place where they propose to vote for at least 6 months preceding the election, and freedom from any disqualification prescribed by law. The 1987 Constitution has retained all these and has added a provision for absentee voting.
Am I alone in your heart? Have I a hope with your heart? She's such a teaser, she's such a star. Give me a reason.
Wake up, youth! This is Akbayan speaking. Over 4 million youths were not able to register for the 2001 general election, and we are going to request a 2-day additional registration. Aww. You know, Kamalek, you need to address the growing political awareness of the youth, so approve a request for an extension.
Remember that month when I only ate boxes of tangerines, so cheap and juicy.
We are filing before this court a petition to set aside and nullify Comelec's resolution and/or to declare Section 8 of Republic Act Number 8189 unconstitutional.
Are you seriously filing a case against me?
Of course I am. Section 8 of RA 8189. is unconstitutional for disenfranchising the youth and others similarly situated, and the issues are as follows. Whether or not Respondent Comelec committed grave abuse of discretion in issuing Comelec Resolution dated Feb 8, 2011, and whether or not this court can compel Respondent Comelec to conduct a special registration of new voters during the period between the original deadline and the 2001 general elections. Oh my god, oh my god, oh my god, oh my god, what's happening? Oh, scandal. Akbayan, see you in court.
The petitions are bereft of merit.
The right of suffrage, although accorded a prime niche in the hierarchy of rights, embodied within the fundamental laws, must be exercised within the proper bounds of the Constitution, and must properly yield to pertinent laws enacted by the legislature. The right of suffrage is not absolute. This right is subject to existing substantive and procedural requirements embodied in the Constitution. This substantive requirement is enshrined in Article 5, Section 1, and the procedural requirement has the right of the citizen to vote is necessarily conditioned upon certain procedural requirements he or she must undergo. In this case, it is the process of registration. Specifically, a citizen, in order to be qualified to receive this right to vote, in addition to minimum requirements set by fundamental charter, is obliged by law to register. At present, under RA number 8189, the Voters Registration Act. Therefore, the act of registration is an indispensable precondition to the right of suffrage. Registration cannot and should not be denigrated to the lowly stature of a mere statutory requirement. Section 28, which provides for the designation of other dates for certain pre-election acts, is explicit. It states there that the Commission shall fix other periods and dates in order to ensure accomplishments of the activities so voters won't be deprived of their right to suffrage. Registration is concededly a pre-election act, but it must be noted that Section 28 does not state that it would go beyond the period in Section 8. Section 28 is anchored on certain pre-election acts and are still capable of being performed, and the election conduct of other pre-election activities required before the law.
The bare allegations of the petitioners that they were disenfranchised are not sufficient. The petitioners were not totally denied of their rights, and in fact, petitioners even admitted that they failed to register for whatever reason. The court stated, "Impuris minibus nemo accedit curiam." Let no one come to court with unclean hands. The petitioners slumbered on their rights.
Now back to normal programming.
The sun! It's gone! But where?
Sometime in 1980, Philip Romualdez, a natural-born citizen of the Philippines, the son of the former governor of Leyte, Benjamin Cocoy Romualdez, and nephew of the then First Lady Imelda Marcos, established his legal residence at Barangay Malbog, Tolosa, Leyte. He served as a barangay captain of the place and acted as campaign manager for Kilusang Bagong Lipunan for the 1986 snap elections in Leyte. After the EDSA revolution, Philip Romualdez, together with his immediate family, fearing for their personal safety, fled the country and sought asylum in the United States.
Welcome aboard, wait.
On September 1991, U.S. Immigration and Naturalization Service informed Romualdez that he should depart from the U.S. at his expense on or before August 23, 1992.
Yes.
Failure to depart on or before the specified date may result in the withdrawal of voluntary departure and an action being taken to effect your deportation.
What's going on?
He arrived in the Philippines and returned to Tolosa on December 1991. Here, he registered himself as a voter to vote for the May 1992 elections. His registration was questioned by Donato Advincula, who alleged that Romualdez was a resident of Massachusetts, USA, that his profession and occupation was in the USA, that he had just recently arrived in the Philippines, and that he did not have the required 1-year residence in the Philippines and the 6-month residence in Tolosa to qualify him to register as a voter.
What's she doing?
Thank you, my loyal subjects. You may approach.
Me? That's you.
Is Philip Romualdez qualified to register as a voter?
See to the Queen. Hey, see?
Yes, Philip Romualdez is qualified to register as a voter. The court treats domicile and residence as synonymous terms. Thus, the term residence, as used in the election law, is synonymous with domicile, which imports not only an intention to reside in a fixed place, but also personal presence in the place, coupled with conduct indicative of such intention. Domicile denotes a fixed permanent residence to which, when absent for business or pleasure or for like reasons, one intends to return.
You naughty son.
Residence thus acquired, however, may be lost by adopting another choice of domicile. To acquire a new domicile by a choice, these must concur. Number 1, residence or bodily presence in the new locality. 2, an intention to remain there. And 3, intention to abandon the old domicile.
And how are you, soldier? Carry on.
Romualdez's residence was established in Tolosa, Leyte in the early 1980s. The EDSA revolution caused a serious concern for the Romualdez family over their safety and welfare. Their sudden departure from the country cannot be described as voluntary or as abandonment of residence, at least in the context that these terms are used in applying the concept of domicile by choice. There is no convincing evidence to prove that Romualdez abandoned his residence in Tolosa, Leyte and established his domicile elsewhere.
Right. Come to the 3. There it is! There it is! Oh, gosh!
ANC News 24/7.